Very happy again to be moderating what we've dubbed a compliance conversation, and this year rejoined by two members who we have as repeat performers, and we've added a third person to the band this year, so we're very glad you've come to join us. Drilling down into the compliance portion of the repossession process, and each of the gentlemen certainly is well known, so I'll leave them to no introduction here, but certainly we'll get started. I'd like to begin with Sean Peterson from the National Independent Automobile Dealers Association, and certainly, Sean, you've been on Capitol Hill many a times and interacting with state and federal regulators on a regular basis. And just if you could just kind of give us an overview of how the repossession compliance environment has behaved recently, just some of the latest trends that have percolated out of the CFPB or other state and federal regulators with regard to repossessions.
Sure, thanks, Nick. Grateful to be here again this year. Thanks for the invitation. Repossession is always an easy target for federal and state regulators to get in. I always liken it to the front door of your house. You know, when regulators are looking for a way in, they're going to find the easiest path, and usually repossession is an easy way for them to get in, and then they can start ripping your house apart and finding certain things. So we've seen action out of state attorneys general's offices over the course of the last several years. But what I find to be very interesting is how aggressive the federal government has been in compliance in this arena, particularly as it comes to military, and I'll get to that in a minute. The CFPB releases what they call supervisory highlights every 6 months or so. And it's a report of their activities as they go into banks and larger finance companies and larger financial institutions where they have the authority to kind of rip their books apart, rip their compliance processes apart. And then they do that's all confidential unless there's some kind of public enforcement action that they take and enter into agreements, that sort of stuff. But the supervisory highlights that they publish every 6 months or so is a summary of some of the things that they found over the course of the last 6 months in doing those confidential supervisions, all anonymous. In fact, they go out of their way to not even give you a hint as to how many companies that they have looked at. So if they make some kind of a finding, for lack of a better term, they'll say one or more companies did or did not do this. But they had a little section in this most recent one talking about repossessions and what some of the things that they have found as they went in and looked at auto finance companies doing repossessions. So a couple of quick things. They found that one or more companies, again, they didn't tell you how many, were repossessing vehicles after the repossession was supposed to be canceled. So there were fact patterns that they said where consumers had worked out some kind of an arrangement with the finance company. Either they had brought the account current or they had entered into some kind of an agreement and understanding with the finance company that their vehicle would be repossessed as a result of some amount of payment or via some agreement. But notwithstanding those agreements, the repossession vendors, the trucking companies or whoever that went out to do the repos, either didn't get word or didn't bother to check again once the order had gone out, is this still legitimate, valid order for repo? So the CFPB said that they dinged a couple of these, one or more of these companies to change their processes, requiring their vendors before they go out and grab that vehicle to do one last check to make sure that it's still a valid opportunity for repossession. So they had a couple remedies that they mentioned. Affected consumers were refunded their repossession fees. They had to change the finance companies had to change their processes and document some specific procedure for their repo agents to follow in checking before they pick these things up. So that's kind of one of the things that we've seen on the federal level. The other thing that we're really starting to see and starting to see much more frequently is the Department of Justice get involved in enforcement actions against finance companies for improper repossession of military service members' vehicles. So under the Civil Service Relief Act, active duty military members that enter into a retail installment retail installment sales contract. I apologize. 5 o'clock flight was it's catching up to me. If they enter into a retail installment sales contract before they engage in full-time military service, once they're called up on active duty, they get certain protections. And one of those protections is against repossession absent a court order. There's a specific process that you have to follow. Well, the Department of Justice has found over the course of the last 2 years or so, 3 companies in violation of the Civil Service Relief Act protections, repossessing these service members' cars without jumping through those hoops to get judicial approval to do so. So I went to law school because math is not my strong suit, but just looking at the sum total of these 3 cases, we're at about $10.6 million in financial relief, either civil penalties or restitution back to these service members, upwards of $10,000 per car. There's a case against Santander from February 2015, City Financial, and Westlake from just this past September. So it's very active on the federal level.
Our next segment speaker here will delve into the world if, in fact, the Department of Justice or whatever perhaps state agency turns into the prosecutorial arm. And I jokingly tried to say to Alan Denson, partner at Hudson Cook, that I hope I don't bring back any bad memories from the mock trials of law school, but asking him to kind of from a 10,000 feet level, just what it's like to try to prepare a defense if in fact some sort of action is taken by a regulator. Alan, thank you.
Well, thanks, Nick. Well, I don't have to go back to law school for this one because this is what I do every day is I am helping folks who are being investigated by the government. And I can tell you that the number one thing that I see people getting in trouble for and getting investigated for is on the collection side, and that includes repossessions, of course. So when I was thinking about what I wanted to say to you all about the challenges that you face, and I want you to remember this word, I want you to remember sub, and it's starting from behind, unclear laws, and big time risk. Okay, so starting from behind, when you are mounting a defense to one of these investigations like Sean talked about, you are at an information disadvantage. So you have either had the regulator in your offices for, let's say, 6 weeks, and they may have 6 examiners who are on site looking at all your books and records, looking at evidence and records of your repossessions, and they are gaining evidence that are the worst examples that they will use against you. Then let's say that you're using an aggregator. Okay, so they're going to go to your aggregator. They're going to get records from the aggregator. Then they're going to get records from the individuals who the aggregator works with. And you are at a disadvantage, even though these people are considered your vendors and you are held responsible for them, you are not getting the complete flow of information that's being handed over to the government. At the same time, the government is also collecting information to use against you from former employees, from customers who have lodged complaints, and that is, you have no insight into that until they file a lawsuit. So you really don't know what the other side knows before a lawsuit is filed. Then you also have the next element is that the laws are unclear. So primarily what you're going to see in this space is that the CFPB, or let's say the Federal Trade Commission or your state regulator, are going to allege that there is an unfair act or practice. And that standard has been around for a really long time, but it's vague and it's difficult to interpret and it's difficult to apply, and it can be viewed on a case-by-case basis. So an unfair practice is a likely or substantial consumer injury that is not reasonably avoidable, and the harms outweigh the benefits to consumers or competition. And that sounds pretty legally, and it sounds like there is a lot of wiggle room in that, and it's because there's a ton of wiggle room. So that information disadvantage and then the lack of clarity in the law, there are not a lot of cases out there that really deal with this issue and whether repos have been conducted unfairly or not. And to Sean's point, even though the CFPB has come out in supervisory highlights and has criticized certain practices, those are not adjudications and they are not binding. They are probably best practices, and they're things that people who are trying to project their risk going forward want to think about and want to consider as they implement their compliance management system. But a court is not bound by what the CFPB says in supervisory highlights. A court is not bound by what the CFPB says in a settlement or what's contained in a DOJ settlement. And I can assure you that there are two sides to every story. So you see only one perspective from the consent orders and from the supervisory highlights. And so the B in sub is big time risk. And what this information disadvantage and the lack of clarity result in is there's a big time risk for creditors out there and for their service providers. And that risk can come in the form of penalties. For an intentional act, you could have over $1 million a day per act. And then you can also get equitable relief, which is equally unclear as the law is. So the CFPB and the regulators, especially in the context of a settlement, they have a lot of discretion as to how much consumers get refunded in restitution or whether they're entitled to restitution at all. So the risks are so great that's I see most of these settling, and you see very few, if any, actions that have been litigated and adjudicated before a court. These are all ending up in settlements because of the disadvantages you face in bringing a defense. So what we really try to do, and I don't want to give you gloom and doom, but I want to let people know that this is the reality of what you're facing. So what we try to do is we try to do a really good job of doing front-end investigation on our end. So that's getting to all the sources of information and understanding what's out there and projecting risks for clients. And then also proactively engaging the regulator, whether that be the CFPB, the Federal Trade Commission, the DOJ, and trying to engage them with what is it that you're seeing and what can we do about it. And oftentimes that cooperative, collaborative approach yields some fruit in that investigations don't take as long, you reach more favorable settlements, and you avoid some of the big time risks that you would face in a court action.
Thank you, Alan. Very well articulated, describing what could happen during the investigation process as you described, and as Sean earlier said, a great foundation of how active the environment is. Turning now to the third member of our panel here, Steve Levine with Ignite Consulting Partners. And Steve, you work with finance companies and dealerships of all sizes and footprints, and certainly it's perhaps not a foolproof plan, but just some general recommendations of what operators and finance companies can do in hopes of shoring up their programs and their protocols to strengthen their compliance processes as much as their resources allow.
Sure. First, thank you for having me. Very happy to be here to talk to everybody today. The first half of my career was spent, I'm an attorney, and I represented car dealers, finance companies, banks, in just about every type of interesting, crazy lawsuit that goes around the industry. Then I had an epiphany that I wanted to help my clients avoid lawsuits, so I became a compliance lawyer, and that's what I do now. We help clients, policies, procedures, training, practices, all things to avoid lawsuits and regular type issues. As these gentlemen have said, there's a lot of risk. Repossessions are inherently risky. So in a limited amount of time, I want to give you 3 good takeaways to try to mitigate some of that risk. First of all, have a clear policy about what triggers a repossession. It used to be when I first started representing the industry that wrongful repossession was a breach of the peace, or something happens at the repossession or the car shouldn't have been repossessed. More and more that's evolved over the years till you find a lot of plaintiffs' lawyers now really try to bring these discrimination cases, saying, why did you repossess my client? It's inconsistent with your policy that there were more ripe subjects for repossession, so that there must be another reason that you repossessed. So, just like you do on the front end of your business where you build a box of deals you're going to buy, you should have some statement of what you're going to repossess. Is it 1 day late? Is it 15, 30 days late? Is it not having contact with the customer? And just list out what that box looks like. And discretion is okay. It's okay to have differences of opinion and discretion, but just have some things set out so that there's clarity and you have something to support the action that you took. I think that's a really important thing to do. You have to be very careful about the metrics that you have. I know some companies that have gotten into trouble because that their metrics drive the behavior. And that's always dangerous because it's, subjectivity is where you run into a lot of issues. So try to have objective metrics, make sure everybody in your servicing department is on the same page and knows what to follow. And if you do those things, you're ahead of the game. Second point I want to emphasize is vendor management. And it seems like the last 5 or 6 years you go to these shows, you hear a lot about vendor management. This is very true in the repossession space. I could tell you from doing this for years, the contracts that the vendors have companies sign are very one-sided. It basically says, I'm going to repossess the car and you're going to pay me. In this day and age, that's really dangerous. You have to have more even contracts. There should be representations and warranties coming from both sides. There should be clear understanding of indemnity. A lot of times there should be service level agreements. The contracts have to be fair for everybody and have to be clear for everybody. Another thing I preach to people is do your due diligence. It always disturbs me when I walk into a company and I ask, well, what kind of due diligence have you done on these vendors? And they really don't do any, or maybe they check their webpage. In this market, I think type of questions you need to ask are, what are your hiring practices? What are your training practices? What kind of education do you give the people carrying out the repossessions? There's a lot of technology that gets used. You have to have a clear understanding of the technology and how it all fits together. If you do those type of things, you're going to be ahead of the game, and you're playing, number one, on an even field with your vendors. You have more knowledge of what they're doing, so hopefully you could avoid some of the bad things that happen. One of the arguments that I've had for years is about the repo agents that want to charge customers to get personal property back. I've always thought that was a bad idea. The CFPB has made it pretty clear that's a bad idea. That should be something that's prohibited in contracts. The regulators are going to impugn that to you, the holder of the paper, even if you're not the one getting the money. You're the one controlling the vendor relationship. So be very careful and don't do that. Third point I want to make is time and time again I see that there is a lot of attention given to, we get the car back, we take the car to auction. There's all sorts of tracking and metrics and tools. Having investment. When it comes to following Article 9, which is basically the rules that govern repossession, there is not nearly the kind of investment of time and resources. You have to know what Article 9 says. You have to know the responsibilities. Any letters that you're using to send to the customers after the repossession should be checked at least once a year. The states do sometimes change wording here and there in the letters. So you really have to know what they say. You have to be careful about any sort of charges that you're adding to the account. Make sure that you can justify all of them legally. You really have to pay attention to all this because there's a lot of tricks. The statutes, it's supposed to be uniform commercial code, but boy, there are variances in every state. So you have to be very careful what state you're in. If you're repossessing from a state that you're unfamiliar with, there are companies out there that do that. They have the letters, they've been vetted by law firms. You're a lot better doing that than using whatever you have in your system and hoping that it's right. So I encourage you, each of those three points, if you improve those areas, you're going to drastically reduce your risk when it comes to this topic. Thanks, Dave.
Excellent takeaway, Steve. Thank you. And during our closing moments here of our compliance conversation, certainly want to give each of these gentlemen at least one more opportunity to share some insight. And we'll go in the same order, begin with you, Sean, Alan, and then Steve. With 2018 literally dead ahead, with the amount of paper that's out on the street nowadays, and it seems like a 60-month installment contract is short-term nowadays. Just whether it's from the regulatory world or just from the general world that we live in, what's kind of on your radar to watch for coming year, and how it might impact repossessions or just the regulatory world in general?
Well, it's kind of funny you said that 60 months is short-term now. The fact that the CFPB just talked about here a couple of weeks ago, they released a little report about the risk of auto paper and the fact that notes are getting longer and longer and longer. I think the one thing that we're going to be very mindful of heading into 2018 is obviously we're going to have a midterm election, and we'll expect a new CFPB director at some point next year. I don't anticipate anything is going to change with the full steam ahead approach of the CFPB, certainly until the new director comes. But once that director, Director Cordray, is out the door, who replaces him? What kind of fight is there in terms of getting him confirmed? But to expect that the idea of having a softer director at the CFPB is going to change how compliance is taken in the industry is a fallacy, because all we're going to see is other regulatory agencies step up and carry that ball, whether it be state attorneys general, the FTC may pick up some things, and who knows, the CFPB may still be very aggressive with whoever takes that place.
Alan?
That's very close to what's on my radar. I think kind of the primary focus that I'm looking at for 2018 is I expect to see a shift from federal to state regulation. So a lot more investigations and enforcement actions from your activist state attorneys general.
And Steve?
What I've seen happen is that the plaintiffs' lawyers have really picked up on what the CFPB is doing, and the CFPB has pretty much given them a playbook on how to attack companies. So you really have to be aggressive in how you build your defense. You can't buy compliance. You can't just magically buy a compliance management system and be off the hook. You have to implement it. You have to train your people. You have to live it every day. If you do those things, you're in a much stronger defensible position when either plaintiffs' lawyers or regulators come knocking at the door. Thanks.
That's Sean Peterson with the National Independent Automobile Dealers Association, Alan Denson with Hudson Cook, and Steve Levine with Ignite Consulting Partners. Please, let's give a generous round of appreciation for each of these gentlemen and the insights that they've shared with us. Thank you.
Thanks, Nick.